Of course, that's really hard to find. A case, same time, roughly similar kind of crime, roughly similar facts, but from a different political party, different political views. You're almost never going to find that, right? Well, amazingly, there might be a comparator like that in this Trump case. I couldn't believe it when I first read about it, but let me explain it to you. It involves Hillary Clinton. You got to remember the core of the case against Trump. What's the core of the case? Prosecution says Trump falsified business records. How? Well, he took some campaign finance expenses. That's $130,000 in hush money paid to Stormy Daniels. The state says those were campaign expenses, but the Trump organization called them legal expenses, and that was false. That's what the prosecution says. That was false. They were campaign expenses, not legal expenses. And because they were campaign expenses, but not reported as such, that's a campaign finance violation. So that was the heart and remained the heart throughout the case of the prosecution's case against Trump. Now here's what's so amazing. In 2022, just a couple years ago, the Federal Election Commission determined that the Hillary Clinton campaign had committed a campaign finance violation. What was it? They found that in 2016, the very same year that these events concerning Trump took place, that the Clinton campaign had paid money to fund the Steele dossier. Remember the Steele dossier? It was a report containing very scandalous and supposedly incriminating allegations against then-candidate Trump. Well, we didn't know it at the time, but it turns out that the Steele dossier had been funded by the Clinton campaign. And when it was discovered that the Clinton campaign had funded the Steele dossier, the Federal Election Commission started looking, well, how did you report those payments? And it turned out that the Clinton campaign had reported them as legal expenses. That's right, as legal expenses. And the FEC said, those weren't legal expenses. Those were campaign finance expenses. And that violates campaign finance law. You can't call campaign expenses legal expenses without reporting them. Well, that's a surprisingly similar set of facts. But here's the thing. They were never prosecuted by the New York district attorneys. And of course, the Clinton campaign was located, headquartered in New York City. So they could have been. And these facts had all come out by 2022. According to public records, there was never a single prosecution, not of Hillary Clinton, not of anybody associated with her campaign, for falsifying business records to cover up a campaign finance violation, notwithstanding the fact that you got, on the surface of it at least, very similar facts. Now, I don't know all the facts of the Clinton campaign finance violation. I only know what's in the FEC public record. But if we accept that public record for what it is, it sure looks like a very similar case. The Clinton campaign called campaign expenses legal expenses to cover up a campaign finance violation, but was never prosecuted for that by the district attorney in Manhattan. If that's true, well, that might be the kind of comparator the courts demand. That might show selective prosecution. And teach and litigate about constitutional law first. Can Trump still run for office? Yes, he can. If you're found guilty, even of a felony, you can still run for president, and states cannot try to take you off their ballot. Whatever you might think about it, paying hush money to keep quiet allegations of an affair or something else, there's nothing criminal, there's nothing unlawful about that. Now, believe it or not, the whole case in the starting phases depends on this. Is there something false about saying that those payments were for legal expenses? Okay, that's step one, because Trump was not charged only with falsification of a business record. He was charged with falsifying a business record to conceal a second crime that he'd already committed. That's how the charges become felony charges. And if you're wondering, it's because he spaced out the payments over 12 months, generating like 3 business records each time, almost 3. You get to 34 counts of false business records. But then the question is, what second crime is the state saying that he was trying to conceal through these allegedly false business records? The indictment said that he'd falsified business records to conceal a second crime, but it never said what the second crime was. What happened was the state never committed itself to which of those crimes it was going to try to allege that Trump was concealing through these business records. And that went up right to the first day of the trial, where they had to come in and show that he was trying to influence an election through the violation of some other statute. And they never said exactly which other statute that was going to be. But the judge did not order a special verdict in this case. The judge ordered what's called a general verdict. And on top of that, the judge told the jury, you know, when it comes to that election law offense with its second crime, you don't have to be unanimous about that. 2 of you could think that Trump was trying to influence an election through a tax violation. Two of you could think that Trump was trying to influence an election by falsifying other records. And a bunch of other people on the jury could think there was some other violation. And the judge said, you don't have to be unanimous about that. Part two, the constitutional issues. A lot of lawyers say that this whole prosecution was unconstitutional. Well, the first thing a lot of people say is, you know what? This prosecution would never have been brought if it hadn't been against Donald Trump. The whole point of the prosecution, people say, is to undermine Trump's chances of being president. Well, if that's true, does that make the prosecution unconstitutional? Answer, yes, it would. That's called, in legal terms, selective prosecution. The state cannot come after you with a criminal prosecution because of hostility toward or in retaliation against your political activity. That's unconstitutional. And if they're doing that, the whole prosecution is unconstitutional. Well, constitutional issue number one is selective prosecution. Now let's turn to issue two, the indictment. I told you before, the indictment charged Trump with a two-step crime, falsifying business records to conceal a second crime, but never said what that second crime was. Is that constitutional? Well, under the United States Constitution, under the Sixth Amendment, every criminal defendant has a right to know the charges against him. And I'll answer it by quoting from a federal case. The court was the United States Court of Appeals for the Second Circuit. And here's what the Second Circuit said. Where an indictment charges a crime that depends in turn on violation of another statute, the indictment must identify the underlying offense. Well, that's exactly what this indictment did. Charged a crime that depended in turn on the violation of another statute, but it didn't specify or identify the underlying offense at the trial. So right up to the day of the trial, the Trump team did not know what the second crime was going to be. Judge Mershon said, that's okay. The state can have a bunch of different theories of what that further statutory violation was. And the jury can pick and choose among them. Well, is that constitutional? I think there's a very serious question about whether that was all constitutional. Because you see, the Sixth Amendment requirement that the defendant be informed of the charges against him, that's not a mere technicality. It's actually like the fundamental principle of constitutional criminal procedure. I think there's a very serious potential Sixth Amendment violation that happened in this case. Now let me move on to the unanimity issue. So remember, what Judge Mershon does is he tells the jury, okay, to find a violation of this New York election law offense, you got to find that Trump was trying to influence an election, namely his own election, through unlawful means, through violating another statute. But you don't have to be unanimous about what the other statutory violation was. Is that unconstitutional? Well, the Constitution does require a unanimous jury. And that requirement, that applies in state prosecutions as well as federal prosecutions. That's only been true for a few years, by the way. It's only a few years ago that the Supreme Court said that unanimity requirement applies to state prosecutions, but it does to state felony prosecutions, and that's what this was. There is a case to be made that that's an unconstitutional jury instruction. You got your three big constitutional questions: selective prosecution, failure to give notice of what the crime was, that's the Sixth Amendment violation, and finally, the danger of an unconstitutional, non-unanimous verdict, which might have occurred in this case. Part three, next steps. Could Trump actually be put in jail? You bet he could. Each count of this 34-count indictment has a maximum penalty attached to it of 4 years. Well, that's 4 times 34. That's a maximum sentence, prison sentence of 136 years. Judge Mershon could sentence President Trump to jail for 136 years. Will he do that? Of course not. He won't. But could he sentence him to some incarceration? Yes, he could. Sentencing is left very much open to the judge's discretion. It'll all be up to Judge Mershon, and nobody knows what he'll do at this time. Now, when is sentencing scheduled for? Well, Judge Mershon has set it for July 11th. Then on July 11th, sentencing will be announced. And at that point, that triggers the Trump team's right to appeal. And after the appellate court rules, then the case could go up to New York's highest court, which is actually called the Court of Appeals, but it's New York's highest court. And after that, the case could go up to the Supreme Court. And ultimately, it might well go to the Supreme Court, where finally we will have a definitive, conclusive ruling on whether the conviction was constitutional or not. Of course, that would take years. And that's a problem here. Why is it a problem? It's a problem because the election will have taken place. And if this conviction is unlawful and unconstitutional, it could have an effect on that election. An unlawful conviction in this case could interfere with and in fact decide the outcome of the next election of the next president of the United States. Even if the conviction were reversed on appeal years later, that effect could not be undone. In legal terms, that's called irreparable harm. District Attorney Bragg and Judge Mershon will have unlawfully interfered with the election and decided the outcome of the next election through unconstitutional means, and no years-long appeal could have any effect on that. Well, believe it or not, there is one other avenue that the Trump lawyers could pursue. They could sue in federal court and ask for an emergency temporary restraining order. Restraining order of what? Well, let me tell you something that you might not know. You've probably been reading in the press, if you've been reading about this case, that Trump is already a convicted felon. The jury has convicted him. He's a convicted felon. Well, guess what? That's not true. You're not a convicted felon because of a jury verdict. You're not convicted unless the judge enters a judgment of guilt against you. In New York, it's very likely that Judge Mershon will enter that judgment of guilt against Trump on the same day that he issues sentencing. That'd be July 11th. So what would this federal case be about? In this federal action, Trump would sue District Attorney Bragg and other state actors and ask the judge, the federal judge, for an emergency temporary restraining order halting Judge Mershon from entering that judgment of guilt until the federal courts have had an opportunity to review and rule on the serious constitutional arguments that exist here. And let me tell you why I think that might be a very important thing to happen. Because going after criminally a former president of the United States and somebody who is running for president now, that's a very bad look for this country. It's an especially bad look when the folks bringing the case and the judge deciding it are members of the opposing political party. And it's an even worse look when the crime is so unclear that the state is hiding the ball about what the actual charges are right up through the trial and indeed into the trial. And even now, we don't know exactly what the jury found Trump guilty of.